was it 549? Somebody tell me 549, is that correct? Brandon, what page are we on? The review and secured transactions, which I think is on page 549? 594. Okay, so Candace, tell me what's going on. We're told that the person went on a spending spree, and what did he buy?
He bought a surround sound system for his home and a kayak.
Sound system, and he bought a kayak and a roof, right?
Yes. And a forerunner.
He bought a forerunner, and then he bought
He bought 6 items.
computers for business use. So man, let me read the introduction to this. Paul Burton owned a small property management company doing business as. Doing business as. What does that mean? Doing business as. So Megan, if you open up a coffee shop and you called it Megan's Place, then that, and you did not incorporate, you ran it as a sole proprietorship, we would say that Megan's Place was a fictitious name, and you were Megan doing business as Megan's Place. So Matt, when it says doing business as, do you think that's going to be an important issue later?
Yes.
Okay. So doing business as, DBA means that it's a sole proprietorship which has not been incorporated, because Sydney, we know that a corporation is a person, but a sole proprietorship is not. Okay. Now, tell me, Kobe, to perfect an instrument, I can perfect an instrument in one of 3 ways. What do I have? I can do it by
Purchasing goods from merchants?
so a PMSI, or I could do it by possession, or I could do it, Kelsey, by a financing statement. Now, Kelsey, to be a PMSI, he's got to be, as Kobe said, it's got to be from a merchant. It's got to be a household good. Well, that's defined in an odd way. And there's a third condition. I always forget that. The purpose of the loan is to buy the goods. The purpose of loan to buy the goods. So Kelsey, if I went to you, if I went to Megan, oh no, you're a coffee shop. So Kelsey, I come to your retail store, and I buy asset A, but I pledge asset B, which I already owns. So let me make sure I understand this. Candace, I buy from Kelsey asset A, but as security for that loan, I'm going to pledge B. Got the story? So Kelsey, would that be PMSI? Because it fails the third condition. Okay, now, let's look at question 1 and question 3. Question 1, Kelsey says, question 1 says, for which of Barton's purchases would go ahead.
Would he need to file a filing statement to perfect the security interest?
So Jody, read question number 3.
Which of these purchases would qualify as a PMSI in consumer goods?
It seems like to me, Sydney, that's 1 and 3 are asking the same question in different words. Does everybody agree? Because the ones I would, so if it's a PMSI, Sydney, I don't need to do a financing agreement. If it's a PMSI, then I don't need to do it. So let's go through the list. Sydney, what about the sound system? Yes or no? Yes. What about the kayak and the roof rack?
No.
What do you think, Jody?
No.
What do you think, Kelsey?
Yes.
So I got 2-1. Matt, what do you think?
No.
3-1.
Yes.
Brandon?
Yes.
3-2. Craig?
No.
4-2. Alex? No. 5-2. Linda?
Yes.
It's gonna take me a long time. 5-3. Kelsey? 5-4.
Yes.
5-5. I need somebody to break the tie. Sherman? Yeah. So yes, it's a PM tie. So last time, Kelsey, we said that clothing was not, but clothing is a different type of item. So basically, if it's a consumer good, but then, what about, Kelsey, what about the vehicle?
The vehicle is not.
No. So it would need a financing statement.
So what's the difference between a kayak and a vehicle? Yeah, that,
But
you
it
can't
goes
use it
on
in your
your
house.
But you can't use it on the road either.
You can use it on the water, and
But
the
you-
water is not out. It's the same thing as with the road.
You probably store it in your house, in your basement.
Oh.
But you could, but you
But
store your
like you
lawn
can say
in
your
your garage.
No, but you
A
farm
better
it.
answer to the question is,
And that's not using it in your house if it's stored in your basement. Storing it's not using.
well, notice it doesn't say used in the house, it says a household good. And also, I think because a better way to deal with the question is to say, why is the vehicle not? And the vehicle is not because there are special rules related to vehicles. And Kayla, does that make sense? Particularly, think about used car lots. And think about used car lots, they're usually operated by people like David. Now, Kelsey, what about the computers for business use?
It's not a vehicle.
So that would need a financing statement. Question number 2. Question number 2, Alex, what's the question? And Taylor, what's the answer?
Suppose that Barton's contract for office computers mentioned only the name Brighton Homes. What would the consequences be if KDM Electronics filed a financing statement that listed only Brighton Homes? Is that
So
what you're saying?
instead of using the name Paul Barton, it uses the name, the fictitious name, the doing business name as, what's the name?
Brighton Homes?
Brighton Homes. So Taylor, what's the implication of that? Is that a valid financing agreement?
No,
Why not? And how do I fix it?
because it's just a trade name, so it needs to include his.
So I should use his name. Now, if this was a corporation, that would be okay, because seeing a corporation as a separate identity from its owners, sole proprietorship does it. Question number 4, Greg, what's the question? And Katie, what's the answer?
Suppose that after KDM Electronics repossesses a surround sound system, it decides to keep the system rather than sell it. Can KDM do this under Article 9? Why or why not?
Katie?
I said yes, because secure parties are allowed to choose not to sell the collateral.
Unless they have made at least 60% of the purchase price, and then that would force a sale. So therefore, and of course, we don't know that. I think it's we don't know that, but Katie, what's the most reasonable assumption? As I read this, these are relatively recent purchases, therefore we probably failed the 60%. So let me restate the rule. If he's paid in, and the logic of this rule, Katie, is if you paid in 95%, which means you paid in almost everything, there's certain protections to the consumer. And so the cutoff is at 60%. At 60%, you can force a sale, but the creditor cannot keep it. And Kelsey, I think that makes sense, because if I only owe 5%, I shouldn't lose the whole thing. So then, Katie, what will happen? He will sell it, and then he should get more for it than I owe, and the excess goes to me. Or unless what? There are other creditors who have a security interest also. So let me do that again. So if we paid in, Kelsey, less than 60%, then that means that the creditor can keep it. If I paid in 60% or more, then I can force a sale, and the excess over the loan goes to me. And that seems fair. Questions? So now, David, watch this. I'll say input. and then I'll say turn on, and then I'll say console. And then it says,
Projector failure.
how do you know?
But yes.
And then I say okay, and then it turns on. Okay. Michael, you want to get the lines? Is that better? Okay. That's better. So Linda, on March the 1st, Green went to Easy Car Sales to buy a car. Green spoke to a salesperson and agreed to buy a car that Easy had in the showroom. On March the 6th, Green made a $500 down payment and signed a security agreement to secure the payment of the balance of the purchase price. On March the 10th, Green picked up the car. On March the 16th, Easy filed the security agreement. Now, the question is, what's the question?
When you're recording.
And when does it attach?
When you pick it up.
On March the 10th. And you agree?
Yeah.
Now, I could have in fact, when I did it, you're smarter than me, because when I read it, I misread the question. And even though it clearly says, what day did it attach? I read it as if, what day did it perfect? And it did not perfect until the 15th. But clearly, and not only is it clear that it asks for attach, but it's even underlined, see? But I missed that. Tellini, under the Secured Transactions article of the UCC, which of the following statements is correct regarding a security entry that has not attached? Basically, Tellini, if it's not attached yet, then it means nothing. So therefore, that being the case, Brandon, what's the answer?
D.
D. Tellini, you agree? Question 3. Megan sells computers to the public. Greg sold and delivered a computer to West on credit. West executed and delivered to Gray a promissory note for the purchase price and a security agreement covering the computer. West purchased the computer for personal use. Greg did not file a financing statement. Is Greg's security interest perfected? So Megan, let's look at A. Yes, because Greg retained ownership of the computer. Well, that's wrong. Let's look at C. No, because the computer was a consumer good. Well, that's wrong. Therefore, Bijou, the answer is either B or D. You agree? And Megan, is this a PMSI?
Yes?
Yes. Therefore, Bijou, the answer is B. It was perfected at the time of the attachment because it's a PMSI. Question number 4. Jody. Without even reading the question, let me just look at the answers. Jody, I've got retailers, I've got wholesalers that sell to distributors, I've got consumers, and I've got wholesalers that sell to buyers. Which one, Jody, is different?
The consumers.
Therefore, Taylor, let's read the question. Mars Inc. manufactures and sells VCRs on credit. What's a VCR? Directly, oh, this is from 1993. Directly to wholesalers, retailers, and consumers. It can perfect the security interest in the VCRs it sells without having to file a financial statement or the possession of VCR if the sale is made to, Taylor, the answer is
C.
C, because that's the only one that would be a PMSI. But Jody, even if I did not know that, the one that is different is often the right answer. Alex, under the Secured Transactions article, and remind me, Alex, to scroll down. Remind me, Alex, that if I do a financing agreement, that's a perfection. If I do a possession, that's perfection. If I do another financing agreement, that's perfection. So it seems like Alex, 1, 2, and 3 are equal because they're all perfected. Therefore, David, you agree they're equal? Therefore, how do I prioritize? Whichever came first, FIFO. Therefore, the answer is A. And David, it seems like to me, that's a much easier question than it looks like, isn't it? Question number 6. Drew bought a computer for personal use, Kelsey, from Hale Corporation for $3,000. Drew paid $2,000 cash and signed security agreement for the balance. Hale promptly filed the security agreement. We paid 2/3 of it, 2/3 of the price. Drew defaulted in paying it because of in paying the balance of the purchase price. He was asked to Drew to pay the balance. When Drew refused, Hale peacefully repossessed the computer. Under UCC, Kelsey, what rights do the consumer has?
You can't force sale to sell a computer.
Katie, you agree?
Yep.
So the answer is C. AJ, under the UCC secured transaction article, which of the following remedies will Hale have? This is the creditor. He will be able to A. Matthew, you agree?
Yes.
Very good. Question number 8. Under secured transactions article of UCC, Michael, what secured transaction document must be signed? I don't know what a statement of assignment is. I know what security agreement is. If you release the collateral, Michael, if you release the collateral, do I need the debtor's signature or the creditor's signature? That's for whose benefit? The debtor, so I don't need her signature, and termination statement. So, Michael, the answer is B. Cindy, you agree?
Yes.
Very good. So now we'll begin three classes on bankruptcy. But Kelsey, the first thing we need to do is a bunch of definitions. So let's begin. A consumer bankruptcy, this is the bankruptcy of a human. Taylor, why don't I say person? What's the difference of human? So you're human. Keith Harrison I don't know about, but you're human. So therefore, are you also a person?
Yes.
Yes. But AJ, a corporation, as we said before, is also a person. So by saying human, I mean non-corporate. Business bankruptcy, this is the bankruptcy of either a corporation or a partnership. But Sydney, notice not a sole proprietorship, because the law does not recognize the sole proprietorship. It's a doing business as. Claim any right to payment. Creditor, an entity that has a claim against a debtor that arose before the filing of the bankruptcy. So therefore, Greg, a debt that arises after the filing of the bankruptcy is not discharged. So Greg, let's suppose that you file bankruptcy on Tuesday and you total Megan's car on Wednesday and then she sues you. Well, that's just bad timing, isn't it?
Yeah.
Because that debt, once she gets a judgment against you, that debt will not be discharged by the bankruptcy. So if you're going to total her car, you should do it before the bankruptcy, and then she'll be screwed. So Megan, your car is total, but let the record reflect that she just kind of,
I don't know.
well, you can, Megan, you can have aspirations. Debt is the liability on the claim. Debtor is an entity going through the bankruptcy. And again, here, Taylor, I use the word entity to mean either a human or corporation or partnership. Entity is a human, corporation, partnership, estate, trust, or governmental unit. So, Kelsey, can a city go bankrupt? But Detroit. Equity and security, stock in a corporation, and interest in a limited partnership are the right to buy such as a stock option. Equity security holder is the one who holds the equity security. An estate, and Kelsey, I don't like this term because when I think of being a tax guy, when I think of estates, I think of when people die, but this is not when people die. This is the estate of the bankrupt, person. A collective term refers to all the debtor's legal and equitable interest in property at the time the bankruptcy is begun. An estate arising at that time that the bankruptcy filed, not to be confused with the estate of decedent, which Kelsey I just did. Exempt property, property which is exempt from bankruptcy, that varies state by state, and we'll talk about that later. That's not part of the estate, that's excluded. Insolvent. There are two definitions of insolvency. Note that a debtor need not be insolvent to file for bankruptcy, but Candace, you must be insolvent to be forced into bankruptcy. Two definitions. Kobe, financial condition of the entity wherein a debtor is not paying her debts as they become due. So you're unable to pay your current assets as they become due. Or, Talini, to put this in accounting terms, your current liabilities are more than your current assets. Because if your current liabilities are more than your current assets, you can't pay your bills as they become due. Or, the debt exceeds the market value of the non-exempt assets. Question. Matt has total debt of $1 million and total assets of 1.5. So Matt, for every $2 of debt, that's $3 of assets. You look pretty healthy to me. Linda, can he be insolvent?
Yes.
Under the first definition, which says what? Unable to pay your debts as they become due. So yes, suppose, Linda, that $1 million of that $1 million, just suppose 800,000 of it is due within the next 60 days. Let's suppose that he only has liquid assets of 100,000. And you've got non-liquid assets, say stock or land, that he would have to convert into cash, and so therefore $800,000 in current liabilities, $100,000 in current assets. Is he insolvent? Yes. Although it's hard to say that he's poor, but he is insolvent. Goes in bankruptcy law. To protect the debtor with a fresh start, anybody can get into trouble. Does anybody know the leading cause of bankruptcy?
Credit cards?
No? Being crazy?
No.
What does this mean?
School debt.
Oh, so, okay. Well, the interesting thing about that, as we'll learn later, you can't discharge student loans in bankruptcy. That's not good. The leading cause of bankruptcy is medical conditions. There ought to be some legislation to fix that. I say so. Ensure equitable treatment of all creditors to ensure everybody gets the same. So therefore, Cindy, you owe me $1,000 and you owe your sister $1,000. You go into bankruptcy, you can't give her preferential treatment over me. So everybody's, and if it were not for the bankruptcy code, you probably would. You still could. How? Just don't report her debt, and then pay her off on the side. As long as you, okay. Bankruptcy courts, judges to the bankruptcy court are appointed by the president, confirmed by the Senate, appointed to 14-year terms, which is different, Kelsey, from other federal judges, which are appointed for life. And the bankruptcy court's appeals go to the U.S. District Court. As you remember, Kelsey, from Legal Environment and Tax Research, District Court is a trial court, except in this one case. It becomes an appellate court with appeals from bankruptcy courts. So, Kelsey, if you lose in bankruptcy, so you're a creditor, you're another creditor of Sydney, and you allege that she gave preferential treatment to her sister. If you lose in bankruptcy court, you can appeal to the district court. If you lose there, you can appeal to the 8th Circuit in Missouri. If you lose there, you can appeal to the big guys, but they won't take it. So, bankruptcy courts are under jurisdiction of the district courts. Types of relief. Chapter 7, which is the most complex, we'll talk about that today. It's a liquidation, which can just means, what's it sound like it means? We take all your assets, we convert them, we take everything you own, we convert it into cash, and then distribute the money out to the creditors. Chapter 11 is a reorganization. In a Chapter 11 bankruptcy, a trustee is appointed to run the business for a period of time. And so the goal here is to make the business survive. Chapter 12, Katie, we won't talk about because it deals with farmers, and that's not on the CPA exam. But it's discussed in the textbook, so you'll never need it. Chapter 13 is adjustment of debts of individual regular incomes. And here, Kelsey, what the court will do is the court will take part, and when we say individual with regular income, who would those be? People with salaries. So employed people, people with salaries, and they have regular income, as opposed making it to your coffee shop, which would be very irregular. And the theory here is that they'll work out a payment plan, and Candace, instead of taking all the assets you have today, which means that the creditors will get less, will extend the payment period over a period of years, and the creditors get more. And 11 and 13 are the most common, but we'll spend more time with 7 because it's the most complex. No comment on that. Chapter 7. It's an ordinary or straight bankruptcy. Debtor turns all assets over to the bankruptcy trustee. Trustee sells the non-exempt property and distributes the proceeds to the creditors. Remaining debts are discharged, and it's not uncommon, Kobe, that a creditor might get 5 cents on the dollar. Available for any person, individual, corporation, or partnership, not a sole proprietorship, and not available for railroads, insurance companies, banks, savings and loans, investment companies, nor credit unions. Kayla, why? Why, for example, do we have special rules for railroads?
They're more regulated.
They're more regulated, and it's hard to understand today because what's the biggest driver of the economy today? I would say it's the internet. 100 years ago, the biggest driver of the economy was the railroads. And think about that, Kelsey, without the railroads, you can't move goods from Maine to California. Insurance companies, again, are heavily regulated, so are banks and so forth. But they have their own special rules. Also, oh, Jody, you know this. Banks, customers in your banks also have FDIC insurance. So they don't need bankruptcy because they're covered by the FDIC. Chapter 7, commencement of the filing of voluntary, involuntary petition. Linda, what's the difference?
If the debtor files, it's voluntary. If the creditor files, it's involuntary.
I'm going to say it better myself. Voluntary bankruptcy, and we'll talk about that today. Wednesday, we'll talk about, what's today? Today's Wednesday? Friday, we'll talk about involuntary bankruptcy. Debtors must receive credit counseling within 100 days of filing and submit certificates. And Kobe, this is new in the law. This came into the law about 10 years ago. And Kobe, who do you think asked for this? Was it the debtors or the banks? The banks. Because, so you can't just wake up today and say, I'm going to go file bankruptcy. You've got to go through credit counseling, and then we'll try to give you advice about how to get out of it. Because if you get out of debt, that means the bank will get the money back. Debtor must confirm accuracy of content. Attorney must file affidavit informing debtor about other chapters. And what that means, Kobe, is that before the court lets you do a 7, you have to be advised of the advantages of an 11 or a 13, because that's what the courts prefer. And why did Kobe? Why does the judicial system? Why does the bankruptcy court prefer an 11 versus a 13? And again, Michael, with an 11, a trustee takes over the business and runs the business until it gets out of the debt. Under 13, Kelsey, the part of your wages would be paid to the bankruptcy court every month, week, however you get paid, and then to the creditors, that means they get more money. Because Candace, with a straight 7, we just take what you have today. So Matthew, we said that if you're going to total Megan's car, you should do it before the bankruptcy. If you're going to win the lottery, you should do it
After.
the day after. Chapter 7 schedules. A list of both secured and unsecured creditors, the addresses, and the amount of debt owed to each. Do you think it's possible, Megan, that some creditors might not even know what they owe? Linda, when you've seen some of our clients about them, it's believable. 2, a statement of financial affairs of the debtor. 3, a list of all property owned by the debtor, including property claimed by the debtor to be exempt. So Candace, if it's exempt, why do I need to disclose it? If it's exempt, that means, Taylor, they can't take it. So if they can't take it, Michael, why disclose it? To verify that it is exempt. A list of current income and expenses. Certificate of credit counseling, as previously discussed previously. Kobe, they won't let you go into bankruptcy until they know there's no alternative. Proof of payment received from employers within 6 days prior to the filing of the petition. Man, I had a client once who was going through a bankruptcy, and he was a student, and he was filing for bankruptcy, and he was a part-time student working a full-time job making about $30,000 a year. He was scheduled to get an increase in salary after he got his degree to $60,000 a year. When should we file the bankruptcy? Before or after? Before he, and go through this list of what we have to disclose. Kelsey, is anything in this list that we have to disclose is no May, and his salary is going to double in September? Anything in this list that requires me to disclose that? No. So, by filing on a timely basis, notice it would have been much worse if we filed in September. Kelsey, is that legal? Absolutely. Is it unethical? Okay. Statement of monthly income itemized to show how amount is calculated. And again, for somebody whose main income comes from salary, this would be very easy to do. For Megan, who owns Megan's shop, coffee shop, it would be somewhat more complex. Copy of the debtor's federal tax return for the prior year. Debtor may be required to show tax returns during the bankruptcy period. There's a substantial abuse test to determine whether or not the petition would be dismissed under Chapter 7. And again, there would be a test to see if 11 or 13 would be better. When I say better, Talini, it's better from the point of view of the creditor. So therefore, Talini, if the creditors are going to come out better with 11 or 13, the court want to let me go with a 7. Substantial abuse test, and there's a basic formula, and it's in the textbook, but Katie, it tends not to be tested in the CPA exam, so we won't talk about it. Applying the means test to future disposable income if debtor's income is above the median income for that geographical area, which in Adair County would be very low. Voluntary bankruptcy. Additional grounds for dismissal, conviction of violent crimes, and that sort of makes sense, Michael, that somebody who's committed murder should not be able to take advantage of the bankruptcy code, or a drug dealer, part of the war on drugs. Debtor fails to pay post-petition domestic support obligations. So, Matthew, you have filed for bankruptcy, you better make sure that you pay your child support. Because if they show that you're not paying child support, they will kick you out of the bankruptcy. Alex, is that appropriate? Or Alex, instead of debating whether it's appropriate or not, what's the policy? The policy behind this is people should pay child support. Voluntary bankruptcy, order for relief, if the filing is proper, filing itself is an order for relief. And what that means, Candace, is that Once I file the order, once I file the bankruptcy, then the court will issue an immediate stay, which means creditors can do nothing else. Creditors can take no additional actions, cannot call me, cannot write me, cannot seize my property, cannot do anything to me until the bankruptcy is done. And Kelsey, if you owed $60,000 in credit card debt, would you be getting a lot of phone calls? A way to stop it would be file for bankruptcy. And this is a good place to quit. Next time, which is Friday, we'll talk about involuntary bankruptcy. On Monday, we'll talk about chapter 11 and 13. Then on Wednesday, we'll do a review, and then what do we do on Friday? Take a test, and then go home. See you then.